My name is Matt Knight, and this video tutorial is all about copyright basics for writers. A little bit about myself. I'm an intellectual property attorney, a fiction writer, and also the author of The Writer's Legal GPS, a guide for navigating the legal landscape of publishing. My publications have appeared in the New York Times, the San Diego Union Tribune, and also my blog Sidebar Saturdays, which is geared to help writers with questions about publishing law. If you want to learn more about me or Sidebar Saturdays, at the end of this tutorial, I've provided the websites for my books and also Sidebar Saturdays, so check those out. And also I should mention that while this video tutorial will focus on U.S. copyright law, I will talk about foreign copyrights and international protection towards the end of the video tutorial. So, with that in mind, let's learn about copyrights. Writers frequently ask me about copyrights. The topic is a tad confusing, but it also is an important concept for writers to understand. Because if you write to earn money, copyrights provide the only protection you have if someone plagiarizes your work, infringes upon it, or otherwise exploits it without your permission. In fact, without copyrights, most writers probably wouldn't be paid a cent because no one would bother to pay them. So, to help you take advantage of the protections provided by the copyright laws, here are 12 basic facts to help you get started. Under the current U.S. copyright law, a copyright is created as soon as you fix it in a tangible medium of expression. It doesn't matter if you type the work down, or you paint it with a brush, or write it with a pen. As long as the expression is tangible, the work is copyright protected. However, the work has to be original, so that means you only get copyright protection in the words that you create, not words or works that you might copy from others. Copyrights protect original expressions, but those expressions need not be just words. Copyright protectable material can also include art, sculpture, audiovisuals, film, photography, websites, software, and architectural designs. To qualify for copyright protection, a work must be independently created by an author and have at least a minimal amount of original creativity. Originality only requires a low level of creativity, what the courts call a spark of creativity. It doesn't matter if the quality is third rate or the work has no merit. In short, the copyright law doesn't distinguish between a New York Times best-selling novel or that poem that you sent to your crush in grade school. Both are works that are worthy of copyright protection. Titles, names, short phrases, slogans, logos, inventions, facts, ideas, and procedures. These are a few things that are not considered to be copyright protectable. Trademark and patent protection, however, which are the other two prongs of intellectual property, may exist for some of those things I just listed. One caveat with regards to facts. While facts per se are not protectable, the way you express the facts, like how you organize, select, and arrange a set of facts, can be copyrighted. For example, a compilation of facts about Star Wars movies or the world of Harry Potter would qualify for copyright protection. Works created by the U.S. government are also not eligible for copyright protection because those fall into public domain for all to use for free. A gracious gift from your U.S. government. Once your copyright material is in a tangible medium of expression, it becomes a form of property that you own. And with ownership, you get a boatload of exclusive rights that we'll talk about shortly. If there are joint authors, each party has equal ownership in the copyright. In order for a joint work to be copyright protected, each contribution to the work must independently qualify for copyright protection. So, ideas, directions, and suggestions, those are not sufficient to elevate someone to author copyright owner status. Like any laws that govern property ownership, copyright ownership can be transferred to another entity or corporation via a written agreement. If the work was created by an employee as part of her job duties, the work is considered a work for hire and belongs to not you, but the employer. It's not always clear whether the author is an employee or a contractor, and the best way to determine this employee status is if the author's relationship is like a salaried job. For example, the copyright in an article written by a staff journalist is owned by the newspaper, whereas a freelance writer, without a work-for-hire agreement, owns the copyright in anything she creates. If the work was made by a freelance writer via a work-for-hire agreement, then the hiring party or corporation owns the copyright. Under the current law, there is no requirement to publish the work to receive copyright protection. Protection applies to both published and unpublished works. But publication can start the clock on copyright expiration under certain circumstances. Mostly this is for older works that enter when they enter the public domain, and also when to register for copyright protection if you want to sue somebody for copyright infringement. I'll talk about both those issues shortly. The thing to remember about publication is that a work is considered published as soon as it's made available to the public, whether via a publisher, the internet, or that flyer that you sent out for your favorite political protest. You are not required to place a copyright notice on your published work to obtain copyright protection. However, it is good form to do so because a copyright notice identifies the owner of the work, when it's created, and puts others on notice that the published work is protected. A proper notice can increase monetary damages as well should you decide to sue. An official copyright notice has three components: the word copyright, or the circle C symbol, the copyright owner's name, and the year of publication. For example, you could use copyright Matt Knight 2020 or Sidebar Saturdays copyright symbol 2020. Either of those would work. The name you use can either be a first name or initials and a last name, or just a last name. A business can use a legally recognized trade name. And also, if you have multiple or joint creators, one name is fine on the copyright. Place the notice on your work when you publish it. The notice can be placed anywhere, but it typically is in the header or footer of the published work. For books, the notice is placed on the copyright page at the beginning of the book. The traditional publisher will do this for you. If you're a self-published author, you're going to have to do that yourself. There's no need to place a copyright on unpublished work, like a manuscript you submit to an agent. The reason is copyright protection exists as soon as the work is in a tangible form. Plus, doing so kind of makes you look like an amateur. Copyrights live a really, really, really long time. For works created after January 1st, 1978, copyright protection lasts for the life of the author plus 70 years. Once a copyright expires, the work enters the public domain and may be used without permission. Works created before 1924 are already in the public domain. As for works between 1924 and 1978, the duration of a copyright can be complicated because of numerous law changes during those time periods. It all depends when the work was created and what law was in effect. So, in general, Copyrights during 1924 to 1978 expire after 95 years, provided a few caveats have been met. So for those time periods, I tend to use a handy chart at copyright.cornell.edu/public domain to help determine if a copyright in a work during those time periods has expired. You are not required to register your work with the U.S. Copyright Office to receive copyright protection. Registration is required, though, if you want to file a copyright infringement suit. So if you want to enforce a copyright, you gotta register. There are certain benefits to filing for a copyright. For example, if you register your work within 3 months after publication or before an infringing act occurs, you can, if you win your copyright infringement suit, you can get statutory damages and attorney's fees, which makes it really nice and beneficial if you decide to sue. Traditional publishers will register for you. Self-publishers, you're going to need to register yourself. And that process is extremely easy. It can be done online at copyright.gov for about $35 and a non-returnable deposit of the work being registered. The owner of a copyright receives these following 5 exclusive rights. The first one, the right to reproduce the work. And this means that your creative expression cannot be reproduced by others unless you have given them permission. Number 2, the right to prepare derivative works. And this means that you can make derivatives, things like abridgments or translations or dramatizations and film versions that are adapted based on the original work. All that is your right solely. No one else can do that unless you give them permission to do so. The third one, the right to distribute the protected work. So a copyright holder has the initial right to control distribution of copies to the public. However, that distribution right does not continue with a copy of the work once it's been distributed. So, if I buy a copy of a book, I can give it away to my friend and not violate copyright law. The fourth one, the right to perform the work. Enough said about that, self-explanatory. And the fifth exclusive right is the right to display the work. This right, like the right to distribute, does not extend to a copy that has been sold by the copyright owner. A copyright owner can take these 5 exclusive rights and license them, sell them in any way, shape, or form that they see fit. Copyright protection does come with a few limitations. And here you thought you had unfettered control over your creative expressions. Sorry. So there is something called fair use under the copyright laws, and copyright does not protect uses by third parties that fall within something called the fair use exceptions. Fair use allows others to use your work without permission if it falls within those exceptions. Typically, fair use covers things like criticism, comment, news reporting, teaching, and research. Unfortunately, determining if something is fair use can get complicated. Under the doctrine of fair use, the courts will use 4 factors when determining whether a particular use is fair. The first one, the purpose and character of the use. For example, is the use commercial or nonprofit? Is it educational? The second factor is the nature and character of the work. For example, is the work that's something that's not copyright protected, like facts and ideas, or is it a novel? The third factor, the amount used in relation to the copyright work as a whole. For example, did you use just a snippet or did you use 12 pages? And then the fourth factor, the effect the use will have on the potential market or value of the copyrighted work. So for example, if you're dipping into someone's pocketbook or their market, taking away market share, then the courts are going to look at that very heavily. If your work is being used without your permission, you have several options. One, you can send a cease and desist letter and request that they stop infringing. Or if you choose to, you can sue in federal court for an injunction, which is an order to stop the infringing act. If you have registered your work in the U.S. Copyright Office within 3 months of publication or before someone infringes, you can request statutory damages and attorney's fees as a remedy. But if you haven't registered your work, only actual damages and lost profits are available as a remedy, which can make a lawsuit financially infeasible. If your infringing work is online and you want it to stop, you can use a DMCA takedown notice to stop the infringing use. There are plenty of examples of DMCA forms online, and basically it's a one-page letter that you send to your internet service provider who's hosting the infringing work, and you request removal. Unfortunately, there is no such thing as an international copyright. Each country has its own laws that govern copyrights within its borders. That said, there are a few multinational treaties that agree to give citizens and foreigners equal protection, provided the country is a signatory to those treaties, such as the Berne Convention, which most of the countries in the world have joined. The U.S. is a member of the Berne Convention, so in the U.S., foreigners receive no lesser copyright protection and benefits than a U.S. citizen receives themselves. So you should treat any creative work, regardless of the country of origin, as if it were from the U.S. This also means that you don't need to secure copyright protection for a U.S. work in every country where the work is published. International protection is automatically extended once the U.S. work is created, and vice versa for foreign countries with the U.S. So for example, if you're seeking copyright enforcement of a work in the U.S., but it's published also in France, that work would be treated under French law exactly as if it were a French work, and vice versa for foreign works in the U.S. That concludes Copyright Basics for Writers. Thanks for listening. If you still have questions, feel free to send those via the contact forms on the websites that are listed at the end of this tutorial. Either one will reach me, and I'm happy to answer them. If not, you are well on your way to understanding the basics of copyright law and the protection it provides.